Solicitors, and Montek Mayal, Senior Managing Director of FTI Consulting. One who are logged into social media, or one who have their arbitration as an arbitrator or as a lawyer or an expert to be taking things forward. They would all know that all three have created their own niche in their fields, and people look forward for their insights in this particular aspects. And to understand all these aspects, we have formulated certain questions which normally do keep arising. In the mind of a common man who's associated with the arbitration as such. Consequently, we will be taking questions wherein the person, or as we associate, like Mr. Stephen would be in the perspectives of as an arbitrator as such, and Mr. Sameer as a counsel, and Montek as an expert. They will also pitch in, and it will be more like a freewheeling session between all these three. And I'm quite sure that people would actually enjoy the perspectives as such. So I will ask Mr. Stephen to unmute himself, and we are not taking much time in the introductions because we believe that all three speakers, being resourceful enough, who have their social media presence as such, as well as on the field of arbitration. And that's the way we, on the platform of Beyond Law CLC, take things forward. One question which we have seen is, what is the role of an expert? Say, the damages expert might play in a commercial dispute, and what type of matters do you often see the experts being engaged for?
Is that question for me, Vikas?
Yeah.
All right, thank you. Again, let me say thank you to Vikas and Beyond Law for having me here, and together with Sameer and Montek. So let me get to the question, which is, what is the role of an expert? So the expert has quite a defined role in commercial disputes, and let me focus on international commercial arbitration because that's the field that I am most familiar with, and obviously I'm not qualified to talk to you about commercial disputes in India. You have much more eminent and qualified people to talk to you about that. So in international commercial arbitration, the expert plays a very defined role. That is to deal with evidence on specialized areas which are usually beyond the realm of counsel, of the lawyers, and quite often beyond the realm of the arbitrators as well. So it's usually not a topic on law, with the exception, I would say, that sometimes there's this idea that if we're dealing with a law, a different law, I hesitate to say foreign law because I don't think there's any such thing as a foreign law in international commercial arbitration, because by definition, international commercial arbitration deals with different kinds of laws. But sometimes when one is dealing with a different law than what the counsel are used to, or maybe the arbitrators are used to, sometimes there's an idea, borrowing from court practice, that you would get the expert to introduce law in that respect. But I don't think that's actually necessary in international commercial arbitration. You can deal with it in other ways. You can submit. It's open to counsel to submit on the law, even if it's not the law that they normally practice in. They can introduce it through legal authorities, etc. So let me put law to one side then. Then what you normally find is there's a specialized area, usually outside of the law, that the dispute turns on, and that we need specialized knowledge on it. That's why we've got experts coming in. This can be, sometimes it could be in the realm of quantum analysis. So a quantum analysis of damages, or it could be a valuation issue. Sometimes valuing the shares in a company or valuing some asset. It could be of a much more technical nature. For example, you have construction disputes, and sometimes there are technical aspects dealing with the construction project itself, whether delay in the construction project or some technical matters in that. Or there could be some technical issue in a more scientific realm that this dispute may turn on. Say if it's a patent-related dispute, there may be technical evidence dealing with the uniqueness of the technology. there's a wide range of issues that come up because there are a wide range of disputes that get dealt with in commercial arbitration. And therefore, you see a wide range of issues in which experts are called to give evidence. But that's the role. The role is to provide the specialized knowledge which the counsel and the arbitrators will need to deal with the issues in dispute. So let me pause there and see whether Samir or Montek wants to comment on that.
I think Samir is mute.
Yeah, Samir is muted.
Yes. So I think I completely agree with you, Stephen, there. And there may be a situation where you need a lot of aspects on a matter apart from law, beyond law, as we call it, which the matter might hinge on. And I remember a matter where Montek was a quantum expert, but we also had an IT expert. We had an expert specifically on Rust, and we had a machine expert. And we also had a Norwegian law expert because the tribunal and the counsel and the parties were not Norwegian law experts. So we had a pool of 5 experts and 2 fact witnesses. And it's interesting on how many places and how many portions you may require an expert to just, kind of put your point across to the tribunal.
I think it's all very well covered already. I'll just the only point I would add from an expert's perspective, and I think it's quite important for us to be aware and for counsel instructing us to be aware, is that in the end, we are there to help the tribunal. We're there to help the tribunal make a more informed decision by providing evidence or analysis which might be relevant to the issues at hand. So I think that's the key distinction, at least from an expert witness versus a fact witness. And it's just good to remember that we're not there necessarily to, we're not there to advocate the case for the client or for counsel. We're there to just answer those questions put to us and be as helpful as possible. And in increasingly complex and complicated cases where that specific knowledge or expertise is important, I believe experts can play an important role to make sure the evidence is in front of the tribunal, so they can therefore, like I said, make a more informed and a more informed decision in the end.
To just summarize it, and the last part of the question was, what type of matters do you think the expert may be required? And speaking from a quantum expert perspective, I think wherever the claim is not really quantified in the contract or by way of an invoice or a document, and where you have to really value the property or the shares, as Stephen said, or damages, to study the market. In all such cases, I would see more often than not, you would require an expert.
Yeah. Now, as we take this forward, now this I will take to Montek, since Montek is an expert. What are the common question of analysis that a damages expert might be asked to opine on or consider? Since you are an expert, a lot of people connect with you, and young students, and especially the youngsters within the profession, would definitely like to ask why the role of the arbitrator is there, or why the expert is there as such. Yeah.
I think Stephen already gave some flavor to it. Maybe let me try to just build on what he's already said. So look, at least when it comes to quantum and damages experts, and as Samir was saying, they often are considered when the cases are more complex, where the questions that need to be answered are not really straightforward. There's uncertainty in the outcome, and answering the question requires a more careful and thorough review and analysis of the wider evidence, and that evidence itself can span multiple disciplines and subjects. So let me give you some examples, of situations where you often find experts and damages experts being used. So where, for example, the questions relate to valuation of businesses or shares, right? So for example, in the context of investment treaty disputes, post-acquisition or post-M&A disputes, shareholder and joint venture disputes, these often in these contexts, the essentially quantifying damages involves business valuations. And therefore, the expert would be asked to value the business, or value a part of the business, or value certain shares in a business, and how that value might have been affected on account of the alleged breaches. So in these situations, the experts will be a damages expert will be someone who has financial and valuation expertise, and then they'll apply the commonly used valuation methods to assess the value of the asset which they've been asked to consider. That's one sort of example where experts are often used. The other ones, it might include loss of profit calculations, right, and which might be quite hopefully a common term to everyone on this panel as well. And that's a routine question which is asked to experts to consider. So, for example, in the context of, say, an early termination of a contract or non-fulfillment of other obligations of a contract, like, say, minimum purchase volumes. So in such cases, again, damages are assessed by comparing essentially the profits that the injured party or the claimant would have made absent the alleged breaches. And sometimes this is referred to as the but-for or the counterfactual position. And that position is then compared with the profits that the claimant has actually earned because of the alleged breaches. And simply put, the difference of the two is the loss. And why does this loss arise? Because the profits that the company would have made or the claimant would have made absent the breach might be higher, because it would have earned higher revenues under the contract. For example, it was sold more products under the contract, or possibly would have incurred lower costs because the claimant ended up incurring costs because of the alleged breaches. So this is a typical question which is often asked experts, is to quantify the lost profits, or what we call also called the expectation loss, sometimes under the contract. And that's a typical issue that comes up in breach of contracts or in a termination of contract kind of disputes. I think the third set of matters that come to us, or issues that we are asked to opine on, could be analyzing costs incurred in business activities or under the contract, or the effects of disruptions and delays on such costs. So, for example, in infrastructure and construction disputes, often the analysis requires how the costs of the project have been affected on account of delays or other disruptions caused by the other party. So again, here the expert will carefully evaluate the costs which have been incurred and how those costs have increased essentially on account of the alleged breaches of the other party. And I think the last set of questions that routinely now come up to us, and I think even in India, it's becoming a more and more hotly debated issue, is essentially in the context of patent infringement or trademark infringement cases or licensing agreement disputes. And here often the question is about the valuation of patents and IP rights. So similar to valuing businesses, in this situation, we are asked to value IP rights or patents which have been affected because they say the infringement, right? So the infringement may have caused the value of the patent owned by your client to have reduced. And therefore, again, the question that is therefore that what is the value of the patent and how that value has been affected by the alleged breaches. I think my intent of giving these examples is to essentially show that many of these questions are governed by principles of finance, accounting, economics, or valuation, and therefore require an expert to analyze such principles and apply a robust framework to answer the damages questions put to them. And like we were saying earlier, tribunals are increasingly seeking expert evidence to make more informed decisions on damages, and therefore it's become even more important to analyze and apply economic and financial evidence properly with the right rigor and ensuring the conclusions are well supported. So these are some examples, Vikas, I hope which will provide some color to the questions that are often put to experts in commercial and investment disputes.
Rather, it adds like a more of a rainbow. It gives a right prisms to the thought process. And the next question, taking further, like I said, that we have all framed those questions. Expert witnesses can be appointed either by the counsel or by the tribunal in the commercial disputes. That is not in dispute. In this background, for anyone, an officer or anybody, what is the difference in appointments or the role of an expert witness by a tribunal versus the party-appointed experts? Is there any subtle difference between the two, or they overlap? What is the things? I would ask first Stephen to take things, and then Samir can chip in his views.
Thank you, Vikas. I think there are two points here I'd like to comment on. One is the situation where you have parties appointing an expert and then a tribunal appointing an expert. And then the other one, which is the second part of the question, is what is the role of an expert appointed by a tribunal versus the role of an expert appointed by the parties? let's start with the second point first. What is the role? And in theory, the role is exactly the same. Right? In theory, the theory being that the expert is there to give his expert opinion, his unbiased expert opinion, based on his professional knowledge, based on his specialized knowledge, and whether he's a tribunal expert or party-appointed expert, he should be giving the same evidence based on his understanding of that specialized area. The practice, it may be slightly different because, and this is not to say anything about the probity of the expert, but the reality is a party will not put up an expert unless he's giving the evidence that they want him to give. They're not going to put up an expert that doesn't agree with their case. Let's just be very commonsensical about this. They're not. I'm not saying that therefore that the expert will tailor his evidence to the party. It's just that when an expert is put forward by a party, the evidence which the expert is giving is the evidence which the party agrees with. So the theory, could be slightly different, and the example, I suppose, of there being at least two sides or two different views on one problem is that you will very often have the situation where there are two party-appointed experts, and they could differ quite markedly in their evidence dealing with the same issue. That's also not a surprise. It's not unknown. It's very common. So you will have that situation where the party-appointed expert is giving evidence which obviously the party that appoints that person wants, suits their case. Now let's then look at the situation of the party-appointed expert. So the tribunal expert. When you look at the situation of the tribunal expert, he's appointed by the tribunal. The tribunal really usually doesn't have a view on these things. I mean, if the tribunal, I suppose one is the tribunal shouldn't have a view on it because that might be prejudging the issue for the tribunal, but also from a more practical point of view, because it's, as we said, as a technical specialized area, the tribunal wouldn't have a view on it. And so they wouldn't have a view on it, and therefore, in that sense, that the evidence that the tribunal appointed expert is going to give will not come from any perspective, simply because the party, the tribunal that's putting him forward, would have no perspective on it. And again, I want to be very clear about this. I'm not saying that therefore party appointed experts are biased. I'm not saying that. It's just that through the process of selection, the party-appointed expert is going to give evidence that suits the party that appoints them. Now, having said that, in over 20 years of practice, I've had over 25 years of practice. I think it's probably 27 years now as a lawyer, but probably about over 20 years focusing on international commercial arbitration. I have never had a case, either as counsel or as arbitrator, in which we've had a tribunal appointed expert. I've never seen it. Does it happen? Yes, it does. And some people say it happens more in the civil law world than in the common law world. But interestingly, I was at one of these seminars in those days when we had seminars and conferences instead of webinars, where there was a civil law arbitrator who had some experience of this. And he also said, one, it was rare even in the civil law world, but also he didn't favor it. He didn't favor it because sometimes what you end up with you have a tribunal appointed expert is the tribunal appoints an expert, and the tribunal, to be fair, has to give the parties an opportunity to appoint their own experts, which they will do. And then you have three experts giving evidence. So it increases the cost. The other point when I thought about this as a tribunal, as an arbitrator, whether if I had to appoint an expert, how would I deal with it? The difficulty we would have, I think, is we're not specialists in this area. How do we brief the expert? What are the points that we need to take up? Maybe then you say you turn to the parties, get the parties to brief the experts. But when you have two parties in dispute, they're not going to agree on many things, and trying to get them to agree on the brief might be difficult as well. So I think that's one issue you're going to have with the tribunal appointed expert, which is how do you brief the expert? I mean, from the party's point of view, this presumably is part of their business, which is why this technical issue comes up. And so they would know what aspects they want to brief the expert on, because the briefing the expert would be just as important as the knowledge that the expert brings, because he's going to come and answer the issue that's put to him. And that's the thing. So the brief constrains to some extent what the expert says as much as the knowledge that he might have. But that's what I wanted to say about tribunal experts and what differences there might be. So let me pause there and see what either Samir or Montek have to add to this.
Well, Stephen, I completely agree with your point of view on this. And while you're right, in theory, there is no difference between a tribunal appointed and a party appointed. But in practice, just because parties are increasingly hesitant to even suggest to the tribunal that they should or they may appoint the expert, this goes on to show that how averse, at least in this jurisdiction, the parties are to get an independent, to get a tribunal expert appointed. But having said that, as you said, it doesn't mean that the tribunal, the party appointed expert is a biased one. All what it means is that a party would want an expert to present that evidence which in their opinion and also in the expert opinion is the strong suit in the case, and may want to wriggle out on the other aspects of the matter. So they're just, I think the sense of being in the driving seat on aspects of what areas to get an expert to cover and what areas to ignore is something which makes a party-appointed expert a more acceptable norm in the international commercial arbitration. Though, now having said that, I had one opportunity, not in an international commercial arbitration, but a domestic arbitration, where very surprisingly the parties agreed to have the tribunal appoint an expert. In that case, what I liked was that there was an increased amount of engagement, and that happens in international arbitral scenarios as well. There's an increased involvement of the parties, both of them, with the tribunal in choosing an expert, and also to provide the points of determination to the expert. So that kind of takes away this whole fear to some extent, not to the 100%, but to some extent that they may not be in the driving seat as far as the expert testimony is concerned. But apart from that, party-appointed expert is the norm, and technically both of them have to do the same role. I don't know if Montek ever sat as a tribunal-appointed expert.
I've come close, but I think often the parties, for some reason, and say that we prefer party-appointed experts. But but I fully agree. I think even as an expert, and maybe Stephen, this is something you can elaborate on, but if needed. But I think sometimes our work, obviously is a function of our own opinion and advice and analysis, but also it is contingent on the instructions we receive, and sometimes the instructions are put to us in a particular way to make assumptions or in facts in a particular way, and the analysis flows from that, right? And there's often a saying in the international arbitration world that experts can be ships passing by at night, because the premise of their calculation is so different that you don't really interact with each other on the opinion itself. So I think party-appointed experts perhaps increase that difference sometimes when the parties are not willing to give instructions or suggest a premise which might not be as beneficial to their case, which obviously therefore impacts the advice or the opinion that an expert will give. And that could be cured itself if the tribunal essentially just instructs them to consider the separate instruction and have common instructions, for example, to start with. But I think that can also be avoided in a tribunal by a tribunal appointed expert, that the instructions can be clear. So the tribunal then has all the answers it requires on different factual and legal premises. So when they make a finding, they know which answer to go for. So that sometimes the instructions of a party appointed expert are such that it causes the premise to be so different that it may not be as helpful then in the end to the tribunal if they were to have come to a finding which is contrary or slightly different to the instructions received by the expert. Stephen, I'm not sure if you have a view on that, because I'm sure you've come across that multiple times as an arbitrator or even as a counsel.
Yeah, I do. And this may be sort of veering onto some of the other topics we're talking about. Since you raised it, I think it's worth talking about, which is, managing expert evidence, particularly from the tribunal's point of view. I think it's rare, at least in my view, that you're going to get both parties agreeing exactly what the issues are that the expert has to give evidence of. And what Montek said about you're getting experts giving different evidence because of the different instructions they have is quite a common scenario. So I've been developing my thinking about how we deal with expert evidence, and one of the things I've been thinking about is, when I first started out, I sort of thought I'm quite in favor of the memorial style of statements of case. So you have the party present their case with their witness evidence, the fact and expert evidence. And that used to be my default. I put the expert evidence there, but I began to change my views slightly in the last years. I think that's where you get the situation where a party just puts their expert evidence forward without notifying the other party what that evidence is. And then you find then that you don't get quite a match either in whether there's an agreement that issue is appropriate for expert evidence to begin with, and even if it is appropriate for expert evidence, what exactly are the issues that you should have. So I've started in dealing with expert evidence now, trying a different procedure, which is we have the parties put forward their case with their fact evidence first. And then when all of the statements of case are out there, all of the witness evidence is out, then we allow the parties to apply to submit expert evidence. And when they do so, they have to submit the issues on which they want to give expert evidence on. And if they agree amongst themselves, that's great. If they don't agree, then the tribunal will have a case management conference and hear the parties and then decide whether or not these issues should be appropriate for expert evidence. That's the first stage. The other thing that I've been thinking about as well, and increasingly in favor of. And when I say these, there is no cookie cutter approach to arbitration. Each case is different, but there are certain approaches that you can adopt. And one of the approaches that I've been thinking of is when you agree on what the issues are that the expert has to give evidence on, instead of having the experts then go off and write their reports and then meet to discuss the reports, I've been thinking it may be better to have the experts meet first, discuss the issues, and then out of that meeting, submit a statement of that meeting, a report of that meeting to say, okay, we agree on these issues. And that's great. When you have the expert agree, then it makes life a lot easier for everyone, including the tribunal, or most probably the tribunal. And then the report that they would deal with then only deals with the issues that they don't agree on. And I've been thinking maybe that's a better approach to take to avoid two issues. One of what Montek said of the experts not meeting each other, passing in the night. But also this idea of sometimes of entrenchment, which is that when you have somebody commit his opinion in writing, he's not going to be quite willing to then turn around and say, okay, maybe what you say, what the other side says has some merit and change his view. He's less likely to do it. But if before he puts anything in writing, he sits and meets with the other expert and have that discussion, there might be more possibility that because there is no entrenchment, there is no stated position in writing as yet, they might be more willing to agree on points and you might get more agreement on that. But that's been my thinking about how we should deal with expert evidence in international arbitration to try and make that process more efficient. Montek, any views on that?
I think it's. I think depending on the procedure where you bring that kind of consideration up, I've anyways always found a joint statement possibly before all the reports are submitted to be helpful. So often, as you know, just for everyone's on the audience, usually The process might be each party submits its report. There might be a provision for a joint statement by the two experts, and then the hearing. But I think, Stephen, at least in my view, sometimes even doing the joint statement prior to the second reports, and the second report can then only focus on the disagreements, like you said, make the hearing more effective. Then you're really focused on the key disagreements which really drive the result or are material to the conclusions. And even the tribunal, I believe, and the counsel, and of course the experts are much more focused on those considerations. I think, but without that substance or without that process, I think otherwise the reports themselves can be quite substantial to deal with, and it's hard to often disaggregate or understand what is causing the differences and what is really the opinion of the experts on the relevant matters. So I think I agree. I think, but I've not yet had. I think I've seen it in construction matters sometimes, where actually now more and more we are seeing tribunals ask for the experts to meet even before the first report is submitted, or even before a substantial evidence has been submitted. But in commercial dispute, I think it still seems to be that it's still not as perhaps structured, and perhaps it's still quite the old form where you submit expert reports. Not all of my matters even have joint statements, for example. So it's still, I think it's still quite novel in that sense as a concept. But I think I do see the benefit of, at least, if nothing else, having a joint statement in place, so you can at least even know what is really causing the difference, if those differences are driven by instructions or a different factual premise, or are those really differences caused by analysis or assumptions made by the experts themselves. Even that kind of clarity, I think, I suspect would be quite useful in most cases for a tribunal as well.
Like Montek and Stephen and Sameer, you have just shared, I was just thinking as to whether do you expect that these roles of an expert, witnesses, etc., especially in the commercial arbitration, would continue, or what are the challenges according to you? I can ask this time that Sameer could give his insights.
Well, Vikas, in my view, it's just the beginning. I think it's going to increase more and more. At least from our jurisdictional perspective in India, I remember it's been only probably 5 to 6 years that people have increasingly started to see value of an expert in an international commercial arbitration or even domestic arbitration, in technical construction arbitration. So I don't see this trend is going to slow down anytime soon. Yes, what I do see, and I'm taking cue from the discussion we had till now, a lot of things need to be ironed out. A lot of ways and means and procedures are getting developed internationally and locally, and I'm seeing more and more thought leadership on how to engage with experts, and the role needs to come out. There'll be guidelines by institutions, and which will get updated. So I'm in my view, I think there'll be quite a lot of development on the formal role of expert in the dispute resolution process, and I'm not even on the consultative role of an expert while you're preparing for a matter from the party's perspective. I mean, we will discuss that. That's a huge different area of experts' involvement in a dispute, which is the consultative role and not really the role on the in the evidentiary hearing. So yes, my view is that this is going to continue. This is not going to stop.
Yeah, Stephen, what would be your take? You endorse what Sameer says, or you have a different thought?
By its nature, the use of expert evidence is not going to go away, because as we started out, we said expert evidence is required where there's some specialized knowledge which neither the counsel nor the arbitrator would be able to bring to the arbitration on their own. So by its nature, you're going to need expert evidence in the appropriate cases. It probably will grow for a number of reasons. One is transactions are getting more complex. There's generally more business that's being done. of which requires a specialized input. I remember being involved not too long ago, but maybe a year or so ago, in an arbitration, Indian-related arbitration involved IP rights. And that would have been a matter in which expert evidence would have been required in the case settled. So we didn't get to that point, but certainly that would have been a matter in which expert evidence is required. And there's been increasingly more use of experts for valuation and damages and that sort of thing. The other thing I suppose that is worth commenting on is the rise of the professional expert. And by the professional expert, I mean people like Montek and others whose main business is to give expert evidence in that particular field. That's something we've seen increasing all over the world. I think it goes hand in hand with what I've said with the rise of business, international business, with the rise of the complexity of the disputes at hand. It goes hand in hand. There's a need, and that's why they're there. But that's something we see increasing. So I mean, maybe to put it in a sort of a personified form, and the fact that that we have Montek here with us, Montek running a business which is primarily to give evidence and expert, suggests that this is definitely not going away. Otherwise, Montek wouldn't be in this business.
And in fact, doing quite well. Not going away and doing quite well.
So since we are talking all about experts, etc., I will ask all three, anyone can take it. Do you believe that the expert should be chipped in at the very infancy stage, even when the thought process is conceived or when the proceedings are initiated? What do you believe what is your take of all three of you in so many years of experience? What do you feel that it should be done at the first brush, or once you proceed, thereafter you should start looking for the expert? Or because they say that if the foundation is strong, the building is strong. If the structure falls, superstructure falls. So what do you feel that for all this arbitration proceedings, etc., what should be your take on these aspects as to whether you should bring the expert at the first instance, or what stage would be the relevant stage? I will ask Montek because he's an expert. Let's ask him to take things forward first.
Yeah, what I'm going to say might seem like a biased answer, but it really isn't. I think.
I was planning to say that you should give a totally unbiased opinion, so that without thinking about your professional gains, that you should be taken at the first instance itself.
And I've got Stephen to put me in line if I'm going to do haywire on my answer. So I think. Look, I genuinely believe that sort of early engagement is helpful. And I'm not saying that because we get involved earlier. I'm just saying that it brings more clarity to even the scope of work, which might be asked to consider. And I think I believe it also makes sure that the evidence which we are asked to put in has the relevant documents are available, the relevant pleadings have been made, and our assessment is consistent with the legal position, the factual position adopted by counsel. So, if I just, for the, again, benefit of the audience, break down the dispute resolution cycle into broadly 3 phases. Let's call the first one an early case assessment, which is prior to the filing of the official pleadings. The second stage would be where the pleadings and the evidence is actually led and submitted to the tribunal. And finally, the hearing itself and any closings that might be conducted after the hearing, and any post-closing submissions that might be submitted. Our view is, or at least our experience is, that an early engagement helps not only, like I said, define the scope properly, identify the documents you will need on the claims you're making, because you don't want to waste your time or money on putting forward claims which are not robust, or which are poorly supported, or which are weak. And that initial case assessment will help you distill the evidence that we will seek to establish and quantify those claims. And we can highlight the concerns we might have as experts to quantify certain claims or the lack of evidence. And that has a second benefit in situations where the documents might be available, but are available with the counterparty. Then you can also seek those documents in disclosure and give reasons. Today, increasingly, tribunals are obviously seeking proper, specific reasons of asking for disclosure documents and why they're required. So in that situation, again, having an expert who's evaluated the claims at the early stage can identify those documents and ask those documents through discovery, through counsel. And like I said, and making sure any analysis that's being performed is consistent with the actual position which has been pleaded by counsel. I've been in so many situations where we've been engaged after the statement of claim or the pleadings have been complete, especially in, I think, in India. And often the quantification they're asking me to do is not even pleaded or not even consistent with the facts and the legal position adopted in the pleading. So you can't then have a damages claim which is inconsistent with your pleaded position. And I think these issues and these nuances are avoided. Similarly, in certain cases I've been in, sometimes additional documents are not allowed to be brought into the pleadings. And therefore my hands are tied because I can only rely on evidence which has been submitted. And if those evidence is in our view not sufficient enough to prove and establish your claim, then again, that's a weakness in the report you'll eventually file. So I think in my view, I think whether it's called case strategy, whether you just call it effective counseling to your client, having a more robust and informed view can never hurt someone, at least in my view. And then you're taking an informed call of which claims to pursue, which ones not to pursue, and in doing so, limit your costs as well, because you're not spending otherwise money on aspects which are going to fail eventually, and all that money is wasted. And because in most international arbitration, at least, I don't think the experience is so much the same yet in domestic arbitration, but I'm sure Samir will correct me, is costs tend to follow the event. So if you're making claims that are substantial and they fail on merit or quantum, then you have a possible exposure to cost of the other side in the arbitration as well. So I think in short, I believe it's more efficient and effective to engage with legal experts, quantum experts, technical experts at the outset, so you can understand the problems, you can understand the case you're making, you understand the claims you want to pursue, and make sure you're only putting forward claims are well supported and have robust evidence underlying those calculations. But again, look, I'll be very happy to take and hear views of Stephen and Samir on what their experience is, especially as counsel on using us. I appreciate sometimes. I must also add, and I don't mean to say this again in a negative way, but there are instances where experts can make your life harder rather than simpler, right? So you need to be careful that you don't overcomplicate things. But I think sometimes on complicated matters, you need to simplify them. I think that's where experts can be useful, and I think that's where they should be used. Don't try to, if your claim is for 2 gold bars lost in a way from one warehouse 1 to warehouse 2, you don't need an expert to tell you what those 2 gold bars are worth. There's a listed and traded price, and someone can easily go get it. And if you get an expert, you will suddenly see a 50-page report on a question that can be answered in 2 pages. So I think simplification is the outcome you're looking for. If that comes through documentary evidence, so be it. If it comes through expert evidence, we can simplify complicated matters and present robust evidence, then that's the way you should go. And I think in both situations, being aware of the claims you want to make and the analysis you want to conduct earlier is helpful eventually in the case in your case. But anyways, I'll stop there and let Stephen and Samir provide their inputs as well.
I think we should hear from the counsel first before I give the arbitrator's point of view.
I would subscribe to Montek's view for once now. We normally are at loggerheads on a lot of issues, but this one is something which I completely subscribe with. I personally am kind of a person who would want to have an expert with me since the beginning, especially in a dispute where the claim is not a straightforward claim or a liquidated damages under the contract. It helps me and the party in quite a few stages. What we see that when someone comes to the dispute, they are sometimes just way too excited and probably in some occasion misinformed in the quantum they expect to claim out of a particular dispute. And from a cost perspective, it's a very important decision to make in the very beginning as to what is the quantum that you're going to claim in your arbitration, because your cost of arbitration more often than not is directly linked with the amount of claim you're making. So at the very beginning, it's very important as a counsel to tell your client that, make a claim which you think is well supported, make a claim which you think if you win on merits, can be awarded. And for that reason, I think it's important to have a consultative expert with you in cases like these. Now, going forward, as Montek said, discovery. Now, discovery being a very, very important aspect to it, to any complex commercial dispute. From an expert's perspective, they would be able to tell you that these are the documents I would need from the respondent if you're a claimant, or from the claimant if you're a respondent, to disprove their claim. And which you as lawyer or a non-technical person, let me put it that way, may not be aware. So during that process, also an expert might be a good person to walk along the whole disputes journey with. Now, having said that, as Montek said, for a simpler dispute, I mean, it should not be a fashion to take expert everywhere you want to claim any amounts in. I have seen instances where the cost of arbitration imposed on the losing party is more than the goods or the intrinsic claim amount they paid to the respondent. So, you need to be very careful in the cost aspect of arbitration, but in a complex matter, it may make sense to have an expert with you since the very beginning.
I think as someone who's also been a counsel as well, look, I would agree with what Montek and Samir are saying, which is that the earlier you get the expert involved, the better. It helps you with various aspects of your case in formulating your damages claim. For example, if you've got the damages that it's a damages expert you're bringing in. Samir makes a good point as well that sometimes in looking at the evidence you need to put forward, or the evidence that you want to try and get from the other side, having that expert point of view is helpful. But let me just add this word of caution, or this perspective from the arbitrator, which is that the earlier the expert gets involved, the more chance there is that the other side, if they want to, may then start to question the independence of that expert. I mean, that's the balance, the fine line that you need to walk. It's not insurmountable. I think, then the expert needs to be very clear when he gets involved, what his role is, and always have in mind that, ultimately he's there to his role for that party is to appear as an independent expert, and he needs to make sure that his independence is not compromised. But the more you get involved at an early stage, the more you get involved in formulating the claim, then to that extent you are eroding your independence, because you are meant to come at this as an outsider and say, I'm just looking at all the facts before me and I'm giving my opinion. But if you've been involved in formulating it, then that's where that line starts to shift. I mean, this is not something where there's a clear, bright line. You're not going to get to a point where it says, yeah, okay, here's the independence sort of border, and here you're independent and this side you're not. It's a spectrum. But the difficulty that looking at it from the perspective of an arbitrator is that the longer you've been involved in it, the earlier involved in it, the more you're involved in actually putting the case together, that's when you are potentially exposing yourself to independence. So I suppose I'd be interested to hear from Montek. How would you deal with that? How do you ensure that you don't compromise your independence when you're helping a party put its claim together?
I think that's absolutely right, and I think we should, we're not there as consulting experts to advise them on what to do exactly and how to frame it in terms of at the outset when they're not clear about themselves or what the losses are. I think we still need to objectively and independently evaluate what they put to us and point out the errors and issues with certain calculations. But I think you're right. I think there's a question that we think about is, and again, like there's no established guideline, I think, on this or a line which is clear cut on it's before this time when you can't be engaged, or after this period of time where you can be engaged. I think you have to. I think the lens that we try to bring in is we answer and we try to give our opinion as an independent expert. So in case if there's a question is asked, on a particular claim, for example, that can this be claimed or not be claimed, we independently try to give our view on if it can and cannot be, given our understanding of it, and how we would quantify it if we would approach as an independent expert. I think when you start getting involved with, like you said, the actual formulation of the legal premise and what you should plead and how you should plead it, I think that's when you perhaps are blurring the line between a consulting expert and an independent expert. But I just wonder, because as an independent expert as well, while your duty is to the tribunal, you still want to give the right opinion and the right analysis on the questions put to you. Because that's in the end also something you need to professionally do. But I think to the extent how far you push that when you're advising your clients on what to pursue and what not to pursue, I think that's where you need to be careful, because that's not really your job. They should come with you and here's my legal premise, here's my factual premise, and here's the losses we are claiming. Now you tell me independently, can we claim these losses? And if yes, how do you establish it? And then go ahead and calculate them. That should be your job. You shouldn't be trying to influence what goes behind the scenes on that factual and legal premise. It's really for counsel to instruct you and tell you about those premises, and we can accept or reject them, and we can say whether they're consistent with what we are claiming or not claiming, but we should not be drafting that for them or influencing that formulation for them. But again, it's a question we deal with live on many matters, and you really want to. I don't think there's a trick to this. There's no one way to do this, but I think but that's the way we try to approach it, and try to stay away from influencing that decision and suggesting what they should do and not do in terms of formulation of the legal claims. But I think we still have to evaluate whether the premise given to us is appropriate, not appropriate, and to what extent it might affect our calculations if we are asked to quantify loss on this premise, right? So it's difficult. I think, but usually a good thing, at least in most matters, is that at least with counsel, they have a view already. They have a strong view of the case and the legal merits and the factual premise. And then they ask us, look, here are the heads of losses we're thinking of claiming. Now you tell us whether objectively these are right, are appropriate, and how would you go about quantifying it, right? No counsel really comes to us and says, hey guys, let's sit on a dinner table and figure out how we can claim this and what we can claim and help us formulate that legal premise. Because that's not our job, right? That's counsel's job. We can only give our opinion and advice on whether we agree or disagree with it and what the shortfalls and weaknesses we think are in those formulations. So I think that's at least how we approach it. But like I said, like you said, Stephen, it's difficult. I think the other thing I would just say is that, and I've not really been questioned that much on this. Maybe I'm opening up Pandora's box by speaking here, but I think most people also, when it comes to the actual objective analysis, I think usually counsel try to focus on picking the real weaknesses in the assessment and biases in the assessment itself, rather than what precise role we might have played or precise stage at which we might have been engaged on. And I think that's something I've seen counsel really focus on. Evidence or analysis is clearly biased or clearly in favoring one party over the other, where there is contradictory or robust analysis available on record which contradicts your opinion. Those tend to be more situations where credibility and independence is actually challenged. I think everyone and all the experts, like you mentioned, professional experts, are also quite aware of the reputational risk of coming across as a not an independent expert, and that's something that's always back of our mind. So we very much try and stick to our line of independence, and if that means disagreeing with parties, disagreeing with counsel, we do that. Because I think that's perhaps a bigger risk in my view, is getting swayed with the opinion of the counsel and parties, and then losing independence in that process, which is a much higher risk. And that's something I think experts should obviously avoid doing, regardless in the matter, in whichever matter they're engaged on.
You mentioned something.
Yeah, Steven.
Just ask one question that Montek raised. It was interesting. I'm just curious because I don't know the answer to this. You mentioned the different roles of experts, right? The consulting expert, which is there really to help the party give his expert opinion, not as an independent, but to help them with whatever expert issue they have, and then the independent expert. Have you come across a case that the party's got a consulting expert already involved, help them put it together, and then you come in as an independent expert? Does that happen? How often does it happen?
So I have been involved, and it has happened. It's strange. Sometimes you don't even know they're there. So I've been on cases where our firm is the independent expert, and there's a consulting expert. A less popular name is called Dirty Expert for everyone on this call. But sometimes we're not even sure, we're not even aware they're there, because our opinion and advice is being sent to counsel, and then they review it, and it comes through us in batch of comments from counsel. And we've been in that situation. So only after the fact we realize there's a consulting expert being engaged in parallel. But we have been engaged where the consulting expert has been brought in very early on. And just again, for everyone's benefit, as a consulting expert, unlike an independent expert, your duty is not to the tribunal, your duty is to your client. In principle, you've been engaged as an advisor to the client. As an independent expert, you sign a declaration that your duty is to the tribunal or the court. And we have been engaged where a lot of thinking has already been gone in to formulating the claims, what to do, what evidence to put forward, what evidence not to disclose. But what we get is that clean and filtered version, right? A clear example, maybe an extreme example of independence versus independent versus a consulting expert would be a consulting expert already filtered out the evidence which they don't want to see, and maybe filtered out the analysis in a way which presents perhaps a rosier picture of the situation. Whereas an independent expert would look at both evidence supporting and those contrary to your case to come to a reasoned, independent answer on the question put to you. So what happens, I think sometimes, Stephen, is that the evidence we get is filtered, and you don't get to see anything else, and you get to see on that. And then, of course, the risk is the other party is aware of it, and then it's brought out. But I think that's one place I've seen where it's come to us in a very filtered fashion, whether the formulation, whether the evidence, whether the case they want to make. And we are given instructions in a narrow way to analyze those claims based on that information made available to us. But I think in many cases, like I said, I think it's someone in very large cases, we've seen consulting experts being retained throughout the proceedings. And then they're in the back end and they will filter their comments. And again, by very definition, those comments are often aggressive or biased, because that's what they're trying to do, is push the number up if you're a claimant, or trying to push the number down if you're the respondent. But again, it comes back to the independent expert themselves. They need to stick up and really, really push back on analysis and evidence which they know is not credible. But what you can see, I mean, the way you notice it is that the evidence, the pushback from the client is much heavier when you know there's a consulting expert behind them who's trying to push the answer in a particular way. But anyway, it doesn't happen a lot, but it has happened before.
And if I may just be allowed a follow-up, this is quite interesting to me, which is that, so from your point of view as an independent expert, is it a good thing or a bad thing that there's a consulting expert involved as well?
I think it's, I mean, it depends how you see it. I mean, if the firm or the expert is strong enough, right? It's never bad to have views, right? You need to test your intellect, and if someone's testing it in a more rigorous way, you're on top of your game. I mean, if you can see it in one form, you see that. And perhaps one of the benefits, as you know, of party-appointed experts was that there's an intellectual debate that happens, and therefore you come to a better answer, hopefully in the end, with both views balanced, right? I think the difficulty is that, so I think wherever the inputs are put to you, you need to evaluate them critically and come to your own reasoned analysis on what you think is correct. But I think it becomes a bit more aggressive. The situation becomes a bit more, I don't want to say hostile is the wrong word for it, but it's a bit more aggressive, right? Because counsel do that as well, right? Counsel want to push numbers sometimes and push evidence in one form, but usually they stop pretty quickly when the independent expert comes with an answer, a harsh answer to their questions. But with the consulting expert, you can see that push is slightly more aggressive. The push is slightly more deep, and they're trying to really, really get you to one place. So I think I don't have a view whether it's good or bad. I think it can often make sure you're on top of your game all the time. I think because there's always some harsh pushback. But I think the only point I would say to take away is really that you can't get influenced by that. I think that's what is critical. You really need to come to a decision or an answer which you are genuinely comfortable with, and you generally think is the right answer. And I have seen sometimes where that doesn't happen, and then you get pressured into it. You call it peer pressure, you call it intellectual pressure, whatever you want to call it, and then you end up giving up views because it's an extreme view, but you think you can support it in an arbitration or in the hearing, and that usually doesn't go well, right? Because it's clear that the expert has chosen an extreme end of a possible spectrum of solutions rather than a more balanced one. And I think that's what in the end you lose credibility with the tribunal as well, because if those assumptions are extreme and are pushed to the edge, then it becomes quite clear in the hearing or by the challenge by the other expert that is the case. So I think it's just perhaps it might become for certain experts it might become slightly harder for the independent expert to hold their ground, and that can obviously have some bad consequences in the end. But otherwise, it's just like anything else. You need to stick to your view, whatever that view is, and come to a reasoned answer.
So just to add on, I completely subscribe to Stephen's view that earlier the expert is engaged, the more questioning on his independence. And therefore, I have been involved as a counsel in a case where we had a consulting expert and a different independent expert. And it's important to, evaluate a scenario where you would want to have your testifying expert involved earlier or at the later stage. If the case allows, then it's always better to have consulting and a testifying expert. Now, what Montek said, I think a lot boils down on the counsel as to how he steers the case and manages his clients. A claimant will always be interested to claim as much as they possibly can imagine. The expectations have to be set right. More often than not, I've seen that clients come in with an evaluated damage list, which probably has been evaluated by their local chartered accountant or the local finance guy within the company. And the objective is to just put a number in front of the management, and the management just comes to the counsel and says, this is what we think we should be able to claim. While once you get an expert on board, they say it's not even what the paper it's written on. So it's important from the counsel's perspective to steer the arbitration and set the expectation of the client well, to advise them to have a proper consulting expert, or if there's one already on board, how to deal with them and to manage the expectation of an independent expert. At the end of the day, what is important is the expert who's going before the tribunal for testimony in cross should be independent and should be able to withhold it. So anything which works around that works well for the case.
Once you three all are agreeing that the expert is an essential, but since we have Stephen as an arbitrator, I would like to ask on behalf of all those participants who are watching that, number one, that how do you assess that this expert is a person who can be vouched upon about his credibility? And number two, how do you evaluate regarding the expectation? What do you expect that this expert should be well versed, and how should he place the things before an arbitrator?
So there are two aspects as you point out. One is what is his expertise, his credibility, what is his standing to give the evidence that he's going to give. So that really depends on his background. Right? He will have to set out what his background is, what his training is, what his relevant experience is, and from that you can see whether he's got the required expertise or not. And sometimes, depending on how the arbitration is conducted, and you will have cross-examination, and some of that may be dealt with. You as the arbitrator might be assisted by the other side's counsel, because he may decide that he wants to try and challenge the expert's credibility, expertise, etc. And then you can take away from that what you want to take away, whether or not the challenge is successful or not. So that's something which it's either apparent on the face of the report itself, on the face of his background, his credentials, or it may come up in cross-examination. The other question was, how do you assess his evidence? How do you assess the cogency of his evidence? especially, and this is obviously an issue for the tribunal because by definition, this is an issue which the tribunal doesn't have any expert knowledge on. So, I really wouldn't know whether what the expert is saying is right or wrong. Because that's not my area of expertise. I mean, sometimes, okay, you may have an inkling, but it really is not your area of expertise. And a lot of it then goes to what Montek has been saying is the internal cogency, right? It is a few factors. It's the internal cogency, it's the reasonableness, and of course, this evidence is going to be tested. You're going to have the evidence from the other expert that you can juxtapose and see, this is what this expert says, that expert says, which one seems more reasonable. But it's also the internal cogency. It is, how does everything stack together? Does it come together as a coherent story? So one thing that tribunals should be able to do, even if they're not experts in that area. I mean, this is one thing that a lot of us who sit as tribunal members should have is the ability to reason. Because we do this all the time. We have to reason. We have to come to a reasoned decision, first of all, but we also work through the issues and decide, who is right and who is wrong. And we can apply that same process of reasoning to the evidence that's being put forward to us and the expert evidence. Even though we don't, have that expert knowledge, it is still possible to apply that process of reasoning to see, when that expert gets from A to B to C to D, is that a logical process or is he stretching it somewhat, that somehow there's some gap between A and C that that it doesn't quite go there, it doesn't quite fit together. Sometimes also it can be quite obvious. I remember, this is quite an extreme case, but I remember sometime back I was sitting as an arbitrator in a case in which it was a construction case, and there were two experts. One came from, say, a non-English speaking jurisdiction. I won't say where, because I might be giving it too much. And I was trying to understand his evidence. And so I asked him, you begin your evidence from this premise. Why do you begin your evidence with this premise? And then, and I said, this doesn't happen often. But what happened next is he then spoke in the language that is not English, that I don't understand, across the room to the client and asked the client the question. And the lawyer who was representing that side was quite honest, and he quickly said, no, stop, we can't have this. And he explained to me what he has just done is to ask the client why we start from that premise. But then, well, okay, after that, it was pretty obvious which way I was going to find as far as the expert evidence was going to go. I mean, it is a rare case, but it's an extreme example to show how what you're looking for ultimately is the cogency, right? Is how is the expert evidence put together? How is it reasoned? And really the truth is when the tribunal has to deal with it, we really can't tell, that this is absolutely right as a matter of fact or scientific evidence or whatever. What we're usually going on is this expert is more persuasive than the other. And the reason why this expert is more persuasive than the other is just that he puts his case together much more cogently, cohesively, reasonably, logically than the other side. That's what we're going on.
So once you have given that how you evaluate, I will ask Sameer, since those who are watching, how do you actually assess that who is an expert and whom should be approached? What is the way forward? Because there's no advertisement at sector. They are the same challenges like what the lawyers have. Only the goodwill travels. Then how do you assess that this expert should be taken chipped in for that purposes of his expertise?
No, very good question. And I think we as counsels always are looked upon and are held responsible by the client and otherwise to have suggested an expert. And therefore, expert choosing is something which comes as a massive exercise at the start or at the stage of the matter when you choose to have an expert. And there are a couple of things. I mean, the knowledge of the industry where the dispute belongs is, I think, the primary qualification which I think an expert must have, because to my mind, quantum assessment is dependent a lot on the market and the industry where the client and the probably the respondent belongs in. So the skill set is extremely important. The knowledge of industry is extremely important. An expert you might want to have for construction dispute might be an absolutely wrong fit for a pure commercial dispute, and vice versa. Another important aspect for an expert while considering is that how well do you think the expert would be able to handle the cross-examination? That's an extremely important part of choosing your expert today. It doesn't really stop at his knowledge. It doesn't really stop only at the quality of the report, but a lot, hinges upon how well the expert, faces the cross-examination, and that skill set is something which we as counsel always consider while choosing an expert. Apart from that, availability is certainly one. Cost is another aspect. Your matter might not be as big as to probably afford a Montek Mayal. You would always consider that aspect of availability and cost while choosing an expert. So these are the few things which I think on the top of my head I would consider, and I always consider while choosing my expert for a matter.
Thank you, Sunil. You've actually told that there's not one size shoe which fits all. You have to choose the expert according to the need. It's just like what we say in the doctor, that he's a specialist in this, he's done the MD or the MS in that particular field. You can't simply go to anyone. You have to find the expert for the purposes for which you are requiring. So once we have with us Montek, I will ask him, what actually, since you are an expert, how can the expert give his insights to facilitate or trigger off the arbitration proceedings in the right way? As in the law, we say that the lawyers are the officers of the court. What is the actual contribution of the expert? How can they increase the credibility, and how do they facilitate or act as a catalyst in the right way?
I think in some ways, based on all what we've been discussing today, in that, like I said, the first and foremost objective of an expert is to give his or her opinion on matters and issues put to them, and they can be helpful by giving the objective and true answer to the questions put to them. I think that's the end goal. And all what we've been discussing today, whether it's through the expertise you have, whether through education or experience, whether it's through the analysis you are proffering out, whether it's the evidence you're reviewing and putting together for the purposes of the expert opinion, I think all that needs to come together, in an objective and a clear way, that the tribunal at least is aware of what the work the expert has undertaken, what analysis he or she have performed, and the reasons for the conclusions they have reached, and that needs to be very, very clearly set out, so that at least the tribunal can then, of course, evaluate that evidence and come to an informed decision on, say, for example, damages. I think the experts can be helpful by just doing their job properly. In short, by just answering those questions and being very transparent and clear on the analysis they've considered. I think the one thing I struggle sometimes is people think that the more complicated or complex you make it, the more sophisticated you come across and more credible you are. I think it's quite the opposite. You need to break it down and simplify the evidence so it's easy to follow, but of course it's well supported, and of course it's backed up by the right evidence and analysis. But I think one thing at least we as a firm try to do very heavily is really focus on the way you draft your expert reports and the way they're written. They should be to communicate with your audience, the audience you have, and the audience you have is the tribunal members and counsel, and of course experts on the other side. So it needs to be very clearly put together that even if it's not relied upon eventually for other reasons, but the premise of your calculation, the premise of your answer, the conclusions are very clearly set out, and they are very easy to follow. So they can be as helpful, like I said, to the tribunal as possible. I think the other thing I would just say is to be, how can they be also be helpful, is to be responsive and to not try to avoid questions. And I think this happens also in cross-examination, where sometimes experts don't answer the questions put to them. I think sometimes that comes through, maybe you are too firmed up on your view, or maybe because you feel that you'll be giving away points by answering the questions properly. But I think in the end, the expert really needs to be responsive, both to the evidence led by the other side, to the extent it interacts with their analysis or it affects their conclusions, or it's a cross-examination where questions being asked by counsel or by tribunal to really give their answer. Right? I mean, to answer. Sometimes we have a short saying again, answer the question put to you. That's what you're there for, and you need to be careful and you need to be honest about those answers. So I think in short, we can be helpful by using our expertise the right way, by presenting our analysis and conclusions in an objective and clear manner, so it's easy to follow. The assumptions are clear, the premise is clear, and then third, being responsive, whether through the expert process itself, i.e. when evidence is produced or submitted by the other side, evaluating critically, and to the extent it necessitates a change in your opinion or an assumption, then to evaluate that properly, or being responsive in a hearing by answering the questions put to you. I think that's at least a few ways, at least I can think about, of how we can be helpful to the process and we can be helpful to the tribunal, because in the end, that's the person you need to convince, whether through credibility or whether through your opinion. Your audience isn't, at least we say this, your audience isn't your client. You can make a client very happy upfront, the number looks big, but it's going to fail if the number is going to be rejected by the tribunal eventually, right? So in the end, you're not doing anybody justice by putting up an inflated claim which is not supported upfront in the proceedings. So I think always try to draft or think about the opinion from the lens of an arbitrator, in how will it be reviewed, how will it be viewed, and what are the evidence you need to convince an arbitrator that your analysis is the correct one. So I don't know, I hope that helps. But I'm will be very happy to hear any comments Stephen has.
Since you said that the credibility has to be counted among, so I will ask Mr. Stephen that how do you ensure that the analysis and the conclusion of this expert is valid or not? Or how do you demolish, let's assume you feel that it is an exorbitant one. As they say, once the lawyers and the expert do chip in, and they always say, like even in the briefs, they say that it's a brief till it runs into 100 pages. So like what Montek was saying, the expectation is of 50 lakhs, but an expert says to make the client happy, he swells it up to 10 crores. So how do you analyze that, and how do you sieve out all that?
Well, and it's the answer is pretty much the same as I had spoken about earlier. But how do I evaluate the evidence in the analysis? It has to be according to the internal cogency of the argument. Obviously, taking into consideration what the other side has to say, who has a more cogent argument. But there are a few things that Montek had said which do resonate with me, because actually the truth is it's not easy to be an expert witness. You may be the most knowledgeable expert in that field, but in order to be a effective expert witness, you must be able to explain that knowledge to somebody who doesn't have that deep knowledge that you have. You must be able to explain it in a simple way. So something that Montek said to me really resonated, which is, it's no use, using a lot of technical knowledge or citing a lot of technical material, speaking at a level which is beyond what the non-experts in that area can understand. What you need to do is to translate that into something, into a language, into concepts which someone who is, reasonably intelligent but not an expert in that field can understand. Now that's a challenge. That really is a challenge, and that's where I think you do need some experience doing it. So when you have professional experts, people like Montek who do this all the time, they get it. But sometimes when you have people come in who have not given expert evidence before, they just speak as if they're talking to people in their field. They just speak that they're talking to somebody else who's equally knowledgeable in that field, and it just goes, way above everybody else's heads. And it's actually, this brings to mind a case which I did quite recently. This time as counsel, or not as arbitrator, and I was brought in quite late in the day. This is trying to make my own excuses, but I was really brought in quite late on the day. The expert evidence had already been put together. I was only brought in as counsel, as a barrister, to argue the case. It was a case. It had to do with a redelivery under a charter party. And the question was whether the ship had been redelivered in the same condition as it had been delivered, and whether the maintenance obligations had been met. And it was literally thousands and thousands of line items about this particular part of that particular machinery. Was it in the same condition? If it wasn't in the same condition, what was the appropriate remedy for that? Do you change it? Do you repair it, etc.? And the way it was presented was just, I think it was beyond me as counsel, because it was the person who gave the evidence wasn't a professional expert. He had never given expert evidence before. He was looking at it from an engineer's point of view. And he came up with this Excel spreadsheet that ran into hundreds of pages. Well, maybe hundreds is a bit too much. But certainly, a significant number of pages in very small print, in tiny, and in literally one sentence. This was, there was no breach of the maintenance obligation. This is fair wear and tear. That's all. And by the time I got in, I looked at it and said, this is awful. But there's nothing I could do about it because it's already been put in. I began really thinking, because I do sit more now than I do appear as counsel. I began thinking, God, how is the arbitrator going to deal with this? This is awful. And I had to try my best to try and present it in a way that was intelligible, but it was really a challenging case, and that's how you really do need someone who not only knows. I had no doubt that the person who gave that evidence knew what he was talking about. He just didn't know how to convey that in a way that somebody who is not a marine engineer can understand. So that in itself is a skill.
Right. Like what initially Montek said, in his lines only, I take cue from that. He says that a lot of people feel that the expert witness is more like a hired gun. What is your take, and how do you segregate that?
Is that a question to me? Is that a question to Steve?
I would ask you because you are on the wrong foot this time. I will ask you subsequently, then how do you create that credibility that you are independent, biased, irrespective of the fact that you have been engaged for that? But how does this arbitrator see out that he's not a hired gun, but his expert opinion does matter, and it will help the settlement of the award in the right way?
I think look, without repeating myself or repeating actually Stephen's words, I think what Stephen said already gave the contours of how an arbitral tribunal will evaluate it. The more an expert can stick to those contours and stick to that reasonableness and the holistic nature of the advice given, opinion given, the supporting analysis, that's how you counter the first sort of tag of being a hired gun. If your answers are biased and are extremely supportive of your client's case, notwithstanding the evidence in disclosure, then that's how you lose credibility and independence, frankly. I would also say, and again, I'll be very happy to get Stephen's and Sameer's thoughts on this, the emergence of professional experts in some ways counters this, in my view, because it's in their interest in forming a career which is credible, to actually not give away or not be biased on a particular case. If you had one-hit wonders, like let me use that phrase, and someone who came and gave evidence once, there's not much repercussions of a biased opinion or answer, right? Because you'll get away with it, yeah, or you won't get away with it. But it doesn't really matter in either case because that's not what you do. I think the emergence of professional experts in some ways is self-regulatory in nature. It self-regulates itself because we make our living and our profession through appearing in front of people like Stephen, other arbitrators routinely. And once we lose that confidence of our main audience, and I keep using that word, my audience is not the counsel or the client. My audience is the tribunal. And whether when you're preparing evidence, like Stephen was saying, it should be presented or prepared in the context of someone like, the arbitrators evaluating it and not perhaps your peers in the industry, or when it's giving the advice, the opinions you're finally concluding on should be viewed from their lens, right? Once a professional expert, I think, loses that credibility of the main audience, then it's very hard actually to get further appointments or to perhaps progress your career in the field, right? So while it might sound great or exciting at the beginning to put a very large number if you're for an injured or for the claimant party, if you lose the credibility in the end, it's going to hurt your client, first of all, because he's going to lose the case. And second of all, as an expert, as a professional, you'll hurt your career because you will not have that much credibility in the market. So I think almost it's a strange situation where the emergence of a particular field has actually further helped people be really careful about what opinions they're giving and how they're being evaluated. I think, but the usual tactics of how do you move away from that label and a cross-examination sort of line on hired gun and client paying your fees, etc. I think that's through the evidence. I think the analysis has to be reasonable in the end. It has to be holistic. It has to be coherent. It has to be internally consistent. And I think that's how you sort of obviously try to ensure that your advice is well understood and well taken by the tribunal, because that credibility and that reasonableness hopefully will support the calculations you've put forward. So I think that's what I would say. I think it's the interest of people like us and the professional experts to be more and more credible. And I think the last thing I would also say is, I think today, at least 12, 13 years I've been now doing this, I see tribunals also quite, I think the awards are far more elaborate on quantum. For example, if you go 20 years back, all treaty awards, etc., were like 2 or 3 pages on quantum. Today, there are 30, 40, 50 pages on quantum itself. So tribunals are taking the evidence and really combing through it with a fine tooth and analyzing what the evidence being put forward and what evidence is contrary, perhaps, for example, to documents in disclosure. And I think in doing that, today tribunals are and courts, I think, and certain courts are far more what's the right word? Far more clear about their preference on evidence, and they're quite clear to point out what evidence was not compelling or not reasonable or was not well supportive. And again, that commentary itself is important because the tribunals today and courts today are able to clearly set out their preference on the evidence itself. And again, obviously, maybe those judgments and those awards are not necessarily public in the context of commercial arbitration. It does go to all the counsel in the matter, right? So it's clear in the end which evidence was used and which evidence was relied upon and which evidence was considered more compelling by the tribunal. So again, that's again a form of self-regulation, because if tribunals are naming and shaming experts and what opinion they didn't find helpful or biased, for example, that again hurts the credibility of the expert for future matters. So I think in these forms, I think in my view, there's enough processes or steps in place that I think people who are genuinely building a career as an expert will be careful in not coming across as a hired gun or a biased expert, right? Because these checks and balances ensure that such experts will not really necessarily last in that profession or last as a credible expert. Because once you lose the confidence of your audience, then it doesn't matter how knowledgeable you are, because your opinion is not going to carry that much weight. But that's my experience. Again, I'm not sure, Stephen, if you have a similar view on that, but or what your experience is, but at least that's the way I think you can come across as a credible expert rather than a hired gun.
It picks up from what we've discussed previously, that we all know that if the expert is coming forward as a party appointed expert, he is going to put forward views which are going to favor that party. It's just the way it's going to be, because if not, he wouldn't be put forward. But then it then goes to how does he present the case? How does he put it together logically? How does he, and to what extent does he, as to pick up what Montek was saying, to what extent does he does he adhere to his professional integrity, right? And it's in that sense, it's not different from being counsel. Right? We all know a counsel is there to argue a case for his client, so his duty is to argue the case for his client. But you can tell, I mean, if a counsel is willing to argue anything, any ridiculous point, then he's going to lose his credibility. Then everything else is going to be affected. And it's how the counsel argues the case, that would reflect his credibility. And it's the same with an expert. We know that you're there to present a view that ultimately will favor the party that has appointed you, but it's how you put it forward that's going to carry the day or not.
I will just add what Montek said in the normal course also. When we see, they say that the trust is like a glass. Once that glass is broken, it's very difficult to bring intact. Your reputation is more like a glass. And so as an expert, I will ask Sameer to unmute himself, and then we take the next question. That it says that the counsel has freedom to prepare an expert. But do you mean in that once the expert is chipped in, then in that eventuality, you say that the evidence has been tampered with, or how do you segregate in that matters? And how involved are the counsels in preparation of the expert report? And what is the value under the legal jurisprudence for that? I will ask Stephen, and then we can ask Sameer as a counsel, what does he feel if there is an expert from the other side while he's appearing as a counsel from the other side? Yeah, over to you, Stephen.
Well, this comes back to something we discussed earlier about the extent to which the expert maintains his credibility and independence. My own view, and certainly what a tribunal would expect, would be that an expert generally drafts his own expert evidence, right? It would be different. I think we'd be more willing to accept that a fact witness statement is not drafted by the fact witness; it is drafted by the lawyer. And we're willing to accept that, but we would expect still it would be drafted based on what the fact witness says. But for the expert witness, though, we would more generally expect that he would draft it himself. Right? That he's not going to be drafted for him by the lawyer. And if it is drafted for him by the lawyer, I think there are going to be some problems there. He probably would not be able to defend it as well in cross-examination, and it would probably come through. I mean, it quite often comes up in cross-examination of a fact witness. Did you actually draft this yourself? And they'll say, oh well, I was assisted by the lawyer who's acting for the party. And most tribunal members are kind of just, yeah, okay, we know what happened. So it's nothing too startling. If the expert witness were to say that, well, I didn't actually draft it, it was based on, I had a conversation with the lawyer and he put it together for me, we would have a bit more concern if that was the case. So, my own view is that as much as possible, the expert, should draft his own report. The lawyer obviously would review it, he can give comments, but I think where the counsel really, or the party, gets to fashion it is before that step, through the instructions. Now that's where you put the sort of the boundaries within which the expert needs to give his evidence. You set that, and then you let the expert go off and produce his report. And if you go beyond that, then personally, I would be quite troubled if that was the case.
I completely agree with Stephen. I think an expert report must not be drafted by the counsel. And from my experience, you're right. It's extremely important to give proper instructions to your expert, and then let the expert do its job. The only involvement from my perspective when I see an expert report is only to understand and see how understandable the report is for someone who is not an expert in that particular area. So I would want to read that report and understand and assess how would the tribunal read and assess the report. Is it easily understandable? Is it communicating the point which the expert is wanting to convey. It's majority of the work goes before the expert report is prepared. Because it's not only expert's reputation which is online, it's also the counsel's reputation which is online. To place an expert which is independent and which comes across as a credible expert, because a non-credible report or an expert may do more harm to you than good in making or forming a perception about your client and the tribunal. Everyone is susceptible to perceptions, and placing an expert or a report which cannot be justified or comes across as motivated or a hired gun is just absolutely a bad call for your matter. So yeah, it's expert report, expert needs to draft.
I will ask Stephen, if there is a conflict between the arbitrator and an expert regarding certain aspect, is it a common phenomena or it's a rare phenomena where there's a conflict between the arbitrator and the expert for the quantification?
You mean a conflict of opinion?
Yeah.
Yes. Not interesting.
It's well, at least in my experience, it doesn't happen, that often, because again, by definition, the arbitrator is not expert in that matter, and the expert is bringing knowledge which the arbitrator doesn't have. So the arbitrator could have questions to try and understand how it's put together logically, etc. But it would be very rare, at least in my experience, for the arbitrator to say, I don't agree with that conclusion because my own conclusion is the contrary. I mean, the other difficulty with that is that the arbitrator then, puts himself at risk of prejudging that dispute because he's giving his own view, without really listening to the other side. So I personally don't think it happens, but I only have my experience as my from what I can speak on. I mean, maybe I'll be interested to hear whether Montek has ever been challenged by an arbitrator to say, I have a different view from what you have.
No, I mean, not really. I mean, at best what we get asked is if a certain factual premise or a particular assumption is found differently, then how it might affect your analysis. And those are often driven by legal points or factual points which there might be disagreements on between the parties, but not yet where they've openly challenged or had come to a different conclusion on an answer that we put forward. So yeah, so I think it's more on they want to have a better understanding of how certain assessments might change if they came to a different finding to the premise we've assumed. But that's more for them to have a better understanding, like I said, of how the damage number might need to be adjusted if they were to come to those alternate findings.
Next question before we part for the day is that do you find, Stephen, the difference between as an arbitrator as well as and counsel, the role of an expert in a common law jurisprudence and vis-a-vis what we do in a civil law jurisdiction? If there are any difference, what are your differences as such, if we can number it out? That
there are not that many differences at the end of the day. And one thing we should bear in mind is that at least in international commercial arbitration, the procedure is already actually a sort of a finding of a medium between the civil law and the common law world. I mean, a lot of the parties would agree to the IBA rules on the taking of evidence, and that already is borrowing from both the civil law and the common law world. As we were speaking much earlier in this discussion about tribunal appointed experts, and that's, as I said, one thing where I've heard that it is more common in civil law jurisdictions than in common law jurisdictions, but my own experience indicates to me that maybe actually that's not true. That's just something that people say, but it really is not that true. So actually, I think in my experience, there is not that much difference whether you are dealing with people who come from a civil law jurisdiction or a common law jurisdiction, or when it comes to their approach to expert evidence.
I think, as we had discussed before going live, and the questions we had received after we had shared it on the social media, these are the broad perspectives which normally come in the mind, and I think a lot of people would have enriched themselves with the knowledge and that too coming from 3 different spectrums. As they say, I don't know about Stephen today, because both of them are from India. There is also a convergence like Ganga, Yamuna, and Saraswati to a common point where we had the knowledge sharing from 3 different sources, ultimately merging together in one source and going forward. And I'm on behalf of Beyond Law CLC, I'm quite happy to share that the session has been well received, and thank you to Mr. Stephen, Sameer, Jain, and Montek. We are too glad for all 3 of you to take out your time and share your knowledge. And we hope that we will join soon. And tomorrow, friends, we have a lot of people do connect with us, especially the youngsters. What is the difference between a briefing and arguing counsel? How do you brief to a senior, and how do you yourself argue a matter? And we, amongst us, tomorrow at 5 p.m., we will be having Mr. Amarjeet Chintyok, a former president of the Delhi Bar Association and a former additional solicitor general, and he's a senior advocate. So do connect with us to have the insights for this session. And thank you once again on behalf of Beyond Law CLC, Mr. Stephen, Montek, and Preet. It was a wonderful and engaging session. Everyone stay safe, stay blessed. Thank you.
Thank you.